Good morning, good afternoon, good evening, everyone, wherever you are on this globe. I am Professor Dr. Milton, and welcome to this session. We welcome all our guests, all viewers, wherever you are in the world. Welcome to this session. To begin with, I wish to recognize the expert panels, some of whom will be joining us in the course of this session. We have Dr. Marota, who is an international director in charge of international programs. He'll be joining us shortly. We have Professor Alessandro Lanciori, who is a professor of law at Perugia University in Italy. She's a distinguished member of this panel who participated in the conference, the plenipotentiary conference that was engaged in the drafting of the Rome Statute. Along with her, we recognize Professor Mercedes Pisani, also a professor of law in Italy and also an ICC counselor. She also participated in the plenipotentiary conference that was involved in the drafting of the Rome Statute. We are privileged to have those two members because we draw from them the wisdom and the original intelligence that was entailed in the drafting of the Rome Statute, which is the basis of the discussions that we're engaged in right now and in other discussions we've had previously and prospectively shall be having. We have Professor Sripathi, a professor of international law in India with over 30 years experience. We have Professor Rama Devi, who is a prominent member of the Government Children's Council in India and also has been professor of international law for a number of years. We have Attorney Brian Ramapakle, who is an outstanding and renowned attorney in Botswana and a well-accomplished international human rights lawyer. And we have many others who are joining us shortly. The session of today, I recognize also Mr. Rao, who is with us here today. And welcome, Mr. Rao. And we start off the session. We are dealing with a situation in the Republic of the Philippines, and we'll be looking at that particular situation and what the International Criminal Court has done. It's an overview, basically. And as an introduction, we'll look at the situation in the Philippines as a background. I'll consider the fact as a start that Philippines is not a state party to the Rome Statute. It was, but it's no longer a state party to the Rome Statute. Effective 1st of November 2011, it was a member. However, it withdrew from the Rome Statute effective 17th of March 2019. So in effect, it is not a member of the Rome Statute. It's not a member of, it's not a state party to that statute. It's not a member of the ICC. And it has no obligations in general to whatever transpires or emerges from the Rome Statute. And that is actually the basis of what the court, the appeal court, and the pretrial chamber contended with, as we shall look shortly. On the 24th of May 2021, the ICC prosecutor requested the pretrial chamber for authorization to commence investigations into the situation in the Philippines. This request was pursuant to Article 15, which therefore was one of the trigger mechanisms available under the Rome Statute, which is a proprio model that is the preserve of the prosecutor of the International Criminal Court. The other two trigger mechanisms are usually referral by the state party, and the third one would be a referral by the Security Council of the United Nations, pursuant to the United Nations Charter, Chapter 7 concerned with the maintenance of international peace and security globally. This particular reference by the prosecutor was in connection with crimes allegedly committed in the territory of the Philippines between the 1st of November 2011 and 16th March 2019. You will note that this particular range of dates coincide or consistent with the period within which Philippines was a member of the International Criminal Court and when it was still a party to the Rome Statute. We just stated in retrospect that Philippines became a state party to the Rome Statute on 1st November, and this, you can see, is consistent with the first date that the prosecutor intended to launch the investigation scope. And it withdrew. Philippines withdrew its membership on the 17th of March 2019. And we can see that the request by the prosecutor of the ICC was confined between 1st November 2011 and 16th March, just one day before Philippines withdrew its membership from the Rome Statute as a state body. That is very instructive, as we shall soon see, in the way the jurisprudence of the court emerged, both at the pretrial chamber and the appeals chamber of the International Criminal Court. So in what context was this referral? The context within which the referral was made emanated or was premised upon the war on drugs, the so-called war on drugs campaign by the government of the Philippines. Paradoxically, when this war was launched against those involved in drugs, other consequential crimes were allegedly committed by officers within the government of the Philippines, which attracted attention of the International Criminal Court. So the context within which these investigations were being conducted by the ICC prosecutor are confined within the limits of the crimes that emanated or emerged from this campaign, the campaign on war on drugs. Now, when the prosecutor approached the pretrial chamber considered the request and authorized the investigation on the 15th of September 2021. That was the first authorization by the pretrial chamber of the International Criminal Court. The Philippines then subsequently requested the prosecutor for deferral pursuant to Article 218 of Article 2. This particular article, I need to mention, refers to deferral and had been rarely invoked previously before Afghanistan, as we shall look at. There's an article I wrote on this with respect to Afghanistan request for referral. Prior to that, we've never had a state invoking this particular article. Essentially, this article requires that, in fact, it is premised upon the principle of complementarity. It requires that once the state in which the authorization has been granted for investigation requests the prosecutor for a deferral, the prosecutor's proceedings would be stopped. The prosecutor, actually, the framing of the article is that the prosecutor shall refer the matter to the pretrial chamber for consideration. In the meantime, therefore, the prosecutor's investigations would not proceed pending the outcome of the consideration by the pretrial chamber of the deferral. In effect, what the deferral says in lay terms is that, look, we, the government of Philippines, are engaged in serious investigations and prosecution and all prosecution of the same crimes that you intend to investigate within our country. Therefore, we ask you to hold on, and we'll be able to demonstrate what we are doing, which is, and if it tallies or it mirrors what you're doing, therefore, you don't have to, to intervene, because under the principle of complementarity, the ICC can only and only intervene by virtue of Article 17 in the investigations of the national criminal jurisdiction, where that particular country is considered not to be genuinely or willing to investigate the crimes or prosecute the offenders. In other words, they say there will be duplication of the same process. Right, that having been observed, on the 18th November, the prosecutor notified the pretrial chamber of the deferral request by the Philippines as a matter of procedure. And therefore, the matter was before the pretrial chamber from that time on. And we saw a new development on the 24th of June, 2022, when the prosecutor requested the pretrial chamber for authorization to resume investigation pursuant to Article 18, Sub-Article 2. Why was the prosecutor requesting a resumption of investigation? It was because the prosecutor had, in his wisdom, established that the kind of investigation, the level and the scope of investigation being conducted by the government of the Philippines was not does not mirror the scope of investigations that the prosecutor had envisaged in terms of the context of the crimes on the war on drugs campaign. So in other words, the prosecutor sought to terminate the request based on the deferral so that to proceed with genuine investigations. That we shall look at when we come to the decision of the pretrial chamber and the subsequent appeal decision of the appellate jurisdiction of the International Criminal Court. Philippines and the victims both made observations to the pretrial chamber during the hearing. The victims are represented by Office of the Public Counsel for the Victims, which is based within the court itself to be able to defend the interests of the victims in a given context. On the 26th of January 2023, the pretrial chamber granted the request upon consideration of all the facts before and evidence before it and representations by all the interested parties before it, granted the request by the prosecutor to resume investigations. In other words, the court arrived at the conclusion that the deferral was not warranted based on the principle of complementarity, as I just stated. And so, because it was not warranted, it was only fair that the prosecutor continue with the investigations from wherever it stopped to resume the investigation. All right. On the 3rd of February 2023, Philippines appealed to the pretrial, they appealed the decision of the pretrial chamber on the basis of a number of facts. So the trial chamber, we saw that authorized in January that there should be resumption of the investigation, but the government of Philippines, being aggrieved by such a decision, launched an appeal against that particular decision to the appellate jurisdiction of the International Criminal Court, which is the appeals chamber. And that was on the 3rd of February 2023. About slightly a month later, on the 27th of March 2023, the appeals chamber rejected the request by the Philippines for suspensive effect of the PTC decision. What do we mean here? In the course of the hearing of the appeal, the Philippines had requested for suspensive effect of the decision of the pretrial chamber, of course, pending the outcome of the appeals chamber. However, the appeals chamber rejected, turned down the application. So on 18th July 2023, that is precisely, that's about roughly 4 or so months later, the appeals chamber arrived at the judgment, and that judgment confirmed the decision of the pretrial chamber. Something interesting about that judgment is that it is controversial. Controversial, why? Because it was a majority judgment. It was not a unanimous judgment. A majority, a very thin majority of 3-2 judges. So it will be interesting to see the kind of decision that was arrived at, the basis, the ratio decidendi that was, the basis of each of the minority opinion and the majority opinion. It is very important, especially when we look at the development of jurisprudence of the International Criminal Court based on this very controversial Article 18, Sub-Article 2, which, as I said, has been rarely invoked in the circumstances of international criminal justice as we know it today. All right, so having said that, the judgment was confirmed by a majority of 3 judges, and we had the minority of 2 judges who agreed with the judgment on the basis, as we shall shortly see. So the judgment was delivered on the 18th of July by the appellate jurisdiction, confirming that, as we just stated, the pre-trial chamber 1. And so that appeal judgment, in effect, granted authorization to the International Criminal Court prosecutor to resume investigations based on Article 18. So what exactly happened? The critical ground of contention or part of departure by the judges was the first ground that Philippines advanced during the appeal. And in this first ground, we had a really controversial decision or opinions by both sides. This is where the majority held their position, and the minority had a contradistinct position. Actually, the minority agreed with the Philippine government, while the majority, 3-2, dismissed the ground. What was this ground? The essence of this ground was essentially that the ICC had no jurisdiction over the matter because the Philippines were no longer members of the ICC or state party to the Rome Statute. In other words, they had already withdrawn from the Rome Statute, and so the ICC had no jurisdiction. That was the argument that Philippines put in, and the minority agreed with that particular argument, that ICC could not exercise its jurisdiction over a situation in Philippines where Philippines was effectively not a member of the ICC anymore, or state party to the Rome Statute. All right, but the other argument that was advanced by the majority was that essentially the scope of investigation was confined within the period within which actually Philippines was still members of the ICC. They were still state parties. If you look at it in retrospect, we did indicate that the scope of the investigation was between 1st November 2011 and 16 March 2019. You see, they confined themselves, the prosecutor confined its request within the scope of duration of membership of Philippines, because Philippines, the government, the Republic of Philippines only withdrew from the Rome Statute on the 17th of March. But the prosecutor sought its investigation between the 1st November to a day before Philippines withdrew. So the majority based anchored its decision on that and said, well, these activities that constitute alleged crimes were conducted during this time within which the Philippines were still member of the Rome Statute as a state party or member of the ICC. All right, the other ground was, so something important or significant to mention at this point, the moment the minority made its decision on that first ground, it saw no basis to consider the other 3 grounds, because it thought that that particular ground was sufficient to dispose of the matter. So as we discuss the 3 other grounds, we'll see that there was no participation by the minority judges on that. It was just opinion of the majority. So the other ground the three judges considered also that the impugned decision, that is the decision of the pretrial chamber, one, does not constitute a decision within with respect to jurisdiction, because essentially that issue was not well brought out by Philippines. Philippines did not bring in the issue of jurisdiction, before the pretrial chamber, and so there was no basis for them to, to adjudicate over that matter. That was their argument, and so they concluded that the decision by the pretrial chamber did not constitute a decision with regard to the jurisdiction of the International Criminal Court. All right, we've noted, as I've already indicated, that the dissenting opinion of the two minority judges was exercised in retrospect, up, as we've just indicated, that Philippines had withdrawn. I've already mentioned that. So they did not consider the other three grounds. Let's look at the other grounds again. The Philippines, being a state seeking the deferral, asserting its conduct with relevant investigations, had the burden of proof. There was a question of burden of proof. There was an argument from the Philippine government of Philippines that unnecessary burden was placed upon Philippines to, produce evidence, where actually the burden was essentially that of the prosecution. But the court discovered that, or found that, came to the decision that there was not necessarily a reversal of burden, but he who alleges in this case, since Philippines was asserting that, so it had the responsibility to discharge of that burden of proof. The other argument Philippines brought was that there was an excessive burden placed upon it. The threshold was much higher than the standard, and that this was not a case already. It was just a situation, because we know we have situations before cases are instituted in the International Criminal Court, and so they said that the admissibility threshold was unnecessarily higher for just a situation in the Philippines rather than a case. It was not yet a case before the International Criminal Court. So the court, by majority, concluded that Philippines failed to show the instances in which the pretrial chamber allegedly applied admissibility threshold or standard. So there was the concern that there was not sufficient willingness or ability to investigate on the part of the Philippines. There are a lot of grounds. I'm just giving an introduction so that I usher our experts in to be able to present their views. So I'm not exhausting everything. I'm just giving highlights for the sake of our viewers and all those interested parties. So the other part was that the court concluded or concurred with the prosecutor that there was not tangible, concrete, or progressive investigative steps being taken on the part of Philippines to be able to exhaust the criminal justice process with regard to the war on drugs campaign. And so it failed. It considered that Philippines failed on that ground. So the totality of international investigation or proceedings presented by the pretrial chamber do not sufficiently or at all mirror the ICC investigations. And so in that case, it warranted that the ICC prosecutor should step in. Yes, so on that note, I've come to a brief summary of what we should be able to present today. And very quickly, I'm going to invite our guests, our experts, some of whom will be joining us shortly, as they've indicated. Others will be joining us in the debate discourse concerning Ukraine. A lot of them will be present. We had our experts, some of them are in very important meetings in Brussels. They've noted that. But as of now, the questions of concern would be the issue of Article 18, Article 2 of deferral, We look at how significant this article has now. Previously, it has not been invoked except in the case of Afghanistan and Philippines, and probably Venezuela and all those other where positive complementarity are being invoked. We look at the appeal judgment, and our experts have their own views. Let me not go very far beyond that point. And on that note, I wish to welcome, we have our international director, an expert in international human rights law, as I've already introduced him in his absentia. He's an expert in human rights, international criminal law. He's well researched and respected internationally, Dr. Giovanni Marotta. We have Mr. Rama Rao as well. So I welcome both of you, and I hope that there'll be contribution made for the benefit of our viewers. Thank you very much, distinguished experts. And that brings me to an end of that introductory remarks. All right, I welcome you, Dr. Marotta, and let's hear from you. Welcome, Dr. Marotta.
Thank you, Dr. Milton. Thank you, Dr. Rama, for being part of this today for this reunion and this panel discourse. We was very appreciate the how Professor Milton has approached the situation in the Philippines, and what I would like to say is that doing an analysis through the dissenting opinion of these of judges Perrin and of Judge Perrin de Richmond and Judge Lord Panisse. I hope I have spelled right the last name. It's important here what they brought during this dissenting opinion related to the situation of the Philippines, because they were related to how the pre-trial chamber erred in law in concluding that the court has jurisdiction of the Philippines. Because here, what the important thing is that we need to learn rather than going through the Radcliffe formula related to how we can bring to justice international criminal perpetrators. There have been since the trial from Nuremberg through the ad hoc tribunals from international tribunals for Rwanda and Yugoslavia, and now that we have international criminal court, including the tribunal for Lebanon, etc. We have learned the importance of the due process. So what these both judges from the ICC they want to express and to show is that now that we are in how we have evolved in relations of prosecuting international crimes, we need to play by the book. So the important here is that the importance of subject matter jurisdiction. So both judges explain in the 13 pages that is their dissenting opinion. They do an excellent work trying to light out this situation, because if we go through the court has not the prosecutor office has subject matter jurisdiction for doing investigations in the Philippines. It's more like the Feinstrafrecht that the Germans call the enemy criminal law. So we are conducting here what we see with the judgment of the pre-trial chamber, with the majority saying that they have that the prosecutor have a subject matter jurisdiction to go further for doing the investigations, and the court has jurisdiction for subject matter jurisdiction for investigating and further trial in these cases. It's a breach there. It's a breach over the foundations of international law, human rights, also related to constitutional law in the matters of the concept of the natural judge and the jurisdiction. So in my opinion, I agree with these two judges, because they're trying to express, if we are going to investigate and we are going to prosecute some crimes, we need to be, we have to have the exact assessment that the court has in every level the subject matter jurisdiction. However, as has been explained by Dr. Milton, how he analyzed these two, the general judgment and the other one that is named the dissenting opinion. We see that there has been a mistake done by the pretrial chamber, by the majority. I don't know if it is I don't know if it is a pressure from mass media opinion for what's going on in this turmoil of international situation that we are going through. What is going on in Ukraine, also what is going in Syria, also what is going in the Philippines. So also what is going between China against Hong Kong and against Taiwan, so and against Nepal. So I probably we will need to make another panel discourse related to how judges should operate, international judges, and then they do not need to be under these international, they're human beings. I understand that. However, I mean, it's important that they apply the treaties, international law, and everything that is related to that, because we can see that in some cases they say they have jurisdiction. In other cases where they have jurisdiction, they say sometimes they say, okay, we are not so sure that we have jurisdiction. So when they need to be more clearly, because it's like the court, the International Criminal Court, through the prosecutor office, is like, is being using, in my opinion, like there is like some kind of political agenda trying to narrow which cases we go proprio mutuo or others not. So this I agree, and I like that in this judgment, two judges have this dissenting opinion, because this will also help for the future cases of the ICC, and also will generate debate, and also through not only through legal professionals, however, through scholars. Thank you for your time. I pass the floor to Dr. Milton.
Sorry for unmuted. Thank you very much for that erudite presentation, Dr. Marota. That was extremely brilliant, and we look forward to more brilliant contributions from you. We have Rama Rao. Hello, can you hear us? Hello, Rama.
Yeah,
thank you very much.
Yes, I can hear you. I just came to listen to. I'm not I don't think I'm a participant. I wasn't on the speakers list. I just came I saw this somewhere and I was interested in the subject. So that's how I came, to listen to what's happening. And I thank you for your brilliant introduction. Absolutely, you summed up the whole thing in a very detailed manner. And so also the director who just spoke. I didn't come prepared to speak on this. To confess, I have not read the Court of Pretrial Chamber Decision 321 of the ICC in this matter. So I would rather listen to others if there are others speaking. But I do say I have an interest in the subject for a very long time. Well, that memory goes back, and I will stop there.
Thank you very much, Mr. Rao. I believe you have some information about the war on drugs. You may not necessarily address the issue of the judgment of the learned judges of the International Criminal Court, but do you think you have something that you may want to share with our viewers in connection with the war on drugs in Philippines, which was actually the essence of this particular referral? And before I allow you to proceed, we have the few minutes of this session. Once it goes off, please just sign back again. When you get disconnected, Dr. Marotta, Professor Marotta, if you get disconnected, please just sign back again onto the session. So Mr. Rao, over to you. Do you have anything that you might want to share with us in connection with the war on drugs in Philippines, or anything related, not necessarily the judgment itself? Over to you, sir.
Okay, now I'll just switch. I'm not prepared, actually. This is my coffee time in New York. So I'll switch on video quickly. Okay, let me just put my earphones. Give me a moment, please.
Good. And remember, if you get disconnected, just log in back again to the session, okay?
Yeah, I hope I won't get disconnected, because I'm not a techie savvy character.
We are going to
Generally.
be disconnected in the next 2 minutes, actually, all of us, for technical reasons, but we shall have to log in again. Yeah.
I see. So just give me a moment and I will. Okay. By the way, I'm not going to speak on okay, I'm trying to see.
All right.
Okay,
yeah, good.
Okay, good. This is me here.
We can see you now. That's great.
Yes, and
Proceed,
this is in New York, morning 9 o'clock.
All right.
Basically, like, I'm interested, as I said, history. Then the current topic is that I was the negotiator in the Rome Conference, and I worked from the ILC Draft Code of Offenses Against Peace and Security, which is the precursor for the draft statute. And in the beginning, in the ad hoc committee, and then the PrepCom, and then the diplomatic conference, and I was in Rome, and I signed the final act of the Rome Statute on behalf of the government of India.
Awesome.
I used to be the legal advisor for India at that time. So I have an emotional attachment to what you were discussing, including the essential principle of the doctrine of complementarity. I mean, I won't claim anything for myself, but doctrine of complementarity was one of the pillars of the Rome Statute in the beginning for many. And then, of course, because particularly those countries who have
brilliant.
democracy.
Okay, we are going off right now and just log in again.
Okay.
That's brilliant. That's brilliant start. Just 1 minute. Okay, you can just proceed until it logs out. It logs us out.
Yeah, I mean, I don't want to talk much about it, actually, because I have not read the plaints, not the plaint of Philippines, not the court majority decision. So, but I can only speak about, one is we are discussing a transitionary state, which was a party, and then it logs out,